Ladies and gentlemen, good morning. My name is Ray McDonnell. I'm the Managing Symposium Editor for Volume 99. And I am very pleased to welcome you all to our Fall Symposium, History, Tradition, and Analogical Reasoning, presented with the Duke Center for Firearms Law. I'll have a couple people to thank at the end of the day, but for the moment, I would like to introduce Professor Joseph Blocher, who will give some remarks, and then we'll get started with our first panel.
Thanks very much, Bray, for the generous introduction. My remarks are going to be very, very short. Again, my name is Joseph Blocher. Along with Daryl Miller here, I am the faculty co-director of the Center for Firearms Law. Sitting just behind Daryl is Andrew Willinger, who is our wonderful executive director, the person at the center who makes everything work. And we could not be more happy to be hosting and partnering with the Law Review on this fantastic symposium. It's wonderful to see it all come together here. The two groups, at least, I want to thank before we get started. One, our wonderful participants, moderators, panelists, people who've some traveled far to be here. We are so grateful to have you all. At the dinner last night, I heard a lot of people say variations of, well, I'm not really a firearms law person, or this isn't really my field, but I've read your papers, and I disagree. I actually think, like it or not, you are all now part of the firearms law field, which for us is incredibly exciting because the mission of the center is to broaden and deepen this area of scholarship involving gun rights and regulation. This is a fantastic group to do that as that conversation, that scholarly conversation, gets more diverse and more sort of polycentric. So we're really excited. The second group I'd like to thank are the students. We have done every year for many years now, at least 6 or 7, I think, which is probably enough to constitute a historical tradition under Broom. We've been doing these symposia, and we have learned that by far the most important determinant of how well they go is having good students to work with, and you all have been extraordinary. I would be remiss if I didn't call out in particular Lexi Graves and Bray McDonnell, who have been just awesome. Thank you both. And with that, I'd just like to introduce Nathaniel Shetter, the editor-in-chief of the Notre Dame Law Review, who will get things kicked off.
Thank you, Professor. As Professor Blocher said, I'm Nathaniel Shetter, the editor-in-chief of the Notre Dame Law Review. I'm very pleased to welcome you all to the law school for our symposium on history, tradition, and analogical reasoning. And we've been so pleased to work with the Duke Center on Firearms Law as well. We have an outstanding lineup of panelists for you today, and I'd like to also make some of my own thank yous. First and foremost to the Duke Center on Firearms Law, especially Professors Daryl Miller and Joseph Blocher and Andrew Willinger, because their vision and drive have made this symposium a success, or we think it will be a success because of their vision and drive. And we couldn't have done it without them. And also the staff, I'd like to thank the staff of the law school, particularly Ann Kelley in Student Services, for their assistance in arranging the logistics for the symposium. Likewise, I'd like to thank Bray McDonnell and Lexi Graves for their tireless work behind the scenes in making this symposium possible. I hope you enjoy the discussions today, that you take a moment to read the final product when it comes out in print in our 4th issue this spring. So with that, I'll turn it back over to Bray to introduce our first panel. Thank you all.
I'd ask our first panelists to please make their way up to the front of the room and take their seats. Fantastic. I'll start introducing our first panel by introducing Professor Kunal Parker. Professor Parker is Professor of Law and Associate Dean for Intellectual Life at the University of Miami Law School. Professor Parker earned a BA from Harvard University, a JD from Harvard Law School, and a PhD in history from Princeton University. Professor Parker's teaching areas and interests include American legal history, estates and trusts, immigration and nationality law, and property. His most recent book, Making Foreigners, Immigration and Citizenship Law in America, was published in 2015. Professor Frederick Schauer is a David and Mary Harrison Distinguished Professor of Law at the University of Virginia. From 1990 to 2008, he was Frank Stanton Professor of the First Amendment at Harvard University and was previously Professor of Law at the University of Michigan. A Fellow of the American Academy of Arts and Sciences, a Corresponding Fellow of the British Academy, and a recipient of the Guggenheim Fellowship, Professor Schauer is the author of numerous books, most recently, The Force of Law. Professor Ryan Williams is Associate Professor of Law at Boston College Law School, having joined the faculty in 2016. He teaches and writes in constitutional law, civil procedure, conflicts of law, and federal courts. Prior to joining the faculty at Boston College, Professor Williams was a Sharswood Fellow at the University of Pennsylvania Law School and an Associate in Law at Columbia University. On Zoom today, we have Professor Barbara Spellman. Professor Spellman is Professor of Law and Professor of Psychology at the University of Virginia. She teaches evidence in various courses on the intersection of psychology and the law. Professor Spellman received her law degree from NYU and her PhD in cognitive psychology from UCLA. She has published in both psychology journals and law reviews. Her book with Michael Sachs, The Psychological Foundation of Evidence Law, was published in 2016. Our moderator for this panel is Professor Bill Kelley, who is Associate Professor of Law at Notre Dame Law School. And with that, I'll turn it over to our moderator.
I'm going to go from here. Good morning, everyone. Thank you for being here. Thank you especially to our distinguished panelists and to all of the people who have traveled and contributed to this symposium. Congratulations and thanks to our students for putting together such a great event. My role is simply to step aside and let the panelists talk about their papers. We have a very interesting collection of approaches here, ranging from a sort of jurisprudential theoretical level to an analysis of historiography and its relationship with originalism, and then a really interesting paper about how this all needs to work in the real world. Symposiums like this are a reflection of the reality that originalism is a bit like the dog that caught the car, and it needs to figure out how to work. And so with that, I'll just turn the floor over to Professor Schauer.
Thank you to all the organizers. Thank you to those who are here. Let me start with two prefaces. One in the division of responsibility between me and my co-author. Probably the best way to describe that is I am really good at getting words down on paper. My co-author actually knows about analogy, going back to her PhD work and a fair amount of writing since then. So that's how we've divided this up. I will mention one other prefatory remark. I look around the room. I am probably the only person in the room old enough to have been drafted. Old enough or male enough to have been drafted. And the relevance of that here is that I am probably the only person in the room who has lawfully fired a fully automatic assault weapon. Maybe there are others, but in any event. Okay, so I just want to briefly describe what we talk about in the paper. the structure of the paper, for those of you who haven't seen it, is to identify two common errors in analogical reasoning, and then talk a little bit about what may flow from recognizing those errors. So the first error in analogical reasoning, in particular in analogical reasoning about law, is an error that is most obvious in Justice Breyer's opinion in Lozman versus the City of Riviera Beach. This is the error of, to use the appropriate terminology from psychological work on analogical reasoning, the error of being overly focused on surface similarities to the expense of deeper or structural similarities. Lozman is a wonderful example of this error. Other than the fact that it deals with analogical reasoning, Lozman is a case that nobody would have been interested in. It's not even clear why 4 justices of the Supreme Court were sufficiently interested in it to grant cert, but nevertheless, there it is. So the issue in Lozman started with a relatively minor, or maybe more than relatively, stunningly minor question about the taxation of Mr. Lozman's houseboat. But it turns out that issues about the taxation of houseboats involve jurisdictional questions, because if a houseboat is a house, then like all other houses, most of the questions about taxation, and therefore the jurisdiction of questions about taxation, are for state courts thinking about property the way that state courts normally think about property. But if Mr. Lozman's houseboat is a boat, and if we add a few other qualifications about the boat's navigability and where it would be navigable and so on, then it turns out that if Mr. Lozman's houseboat is a boat, then the appropriate jurisdiction for the dispute is federal courts in admiralty, and therefore the issue in Lozman is his houseboat a house or is it a boat? The reason that what I describe as an error surfaces in the case is that Justice Breyer talks about various different features of this thing. I won't call it a house or a boat. Talks about various different features of this thing, but almost all of the features that he talks about are the ones that one can observe. And in order to reinforce that point, the opinion provides pictures of the houseboat, all designed to reinforce Justice Breyer's view based on observation of surface features that this is a house and not a boat. I should have brought pictures, but take my word for it or take our word for it. He focuses overwhelmingly on what it looks like rather than what it does, rather than deeper structural features. So that's the error of surface similarity. If we transpose that into the context of firearms, one can imagine, although it is harder, one can imagine things that looked like the firearms of 1791 or 1868, but are dramatically different in function, dramatically different in structure, dramatically different in various other ways. So at least the initial problem, I would suggest, that needs to be avoided in engaging in the analogical reasoning process that Justice Thomas describes, is trying to get beneath the surface similarities and look at the more significant structures and functions that would either differentiate or analogize the weapons of earlier times to the weapons of now. Error number 2, I want to call the error of, let's call it the rush to legal realism, or the error of the rush to skepticism. Here, the principal skeptic and the principal culprit is Judge Posner. So Judge Posner starts with the observation, along with his fellow skeptics Larry Alexander and Peter Weston, starts with the observation that in some respects everything is like everything else, and the related observation that in some respects everything is different from everything else. That any two items in the world have features that they share in common, even if only the feature of existing at the same time, and features about which they are different. So Judge Posner takes this fact to be a justification for the conclusion that if we want to analogize any two things, we need what we call a rule of relevance, explaining which features are important and which features are unimportant, and therefore why two things are similar to each other even in the face of differences. Judge Posner takes the existence of a rule of relevance to be sufficient for saying, well, given that judges always have to create a rule of relevance, explaining why two things are similar to each other, or in other cases why they are not, then, not surprisingly for Judge Posner, he says the rule of relevance has to be created in light of what the judge thinks is the best result in this particular case. But it turns out, and here I tread more cautiously into cognitive psychology, people don't think that way. That is, one of the things that we know from the empirical experimental research about analogical reasoning is that people often go from particular to particular, rather than going from particular up to the abstraction of a rule of relevance and then back down to particulars. Rather, they go from particular to particular without ever thinking that there is a rule of relevance, a rule of similarity. And if this is what, in fact, people are doing, then it turns out that what people are actually doing when they go from particular to particular is identifying what seem to them to be similarities without getting to the stage of how should this case turn out, what would be the best result in this particular case. And at that point, and I'll finish with this, at that point, there's another area of cognitive psychology research that becomes particularly relevant here. And here I'm describing briefly, I should let her describe it, but briefly, the conclusion from a fair amount of the existing research that when people are deciding what it is that is similar to what, they are substantially influenced not by what the outcome of a case should be, but rather by their own education, their own background, their own experiences. So therefore, when a judge is deciding whether this firearm is or is not similar to that firearm of 1791 or that firearm of 1868, that judge is highly likely, maybe even of necessity, to make that determination based on the judge's experience with firearms, the judge's knowledge of firearms, the judge's education about firearms, and a whole range of, let us call them idiosyncratic factors that go to particular judges' knowledge, experience, education, and the like. And unless we recognize that, unless we recognize the background of the judge in making these determinations, we will never get the enterprise of evaluating analogies off the ground. I'm going to stop with this, and I will turn it over to my co-author if she wants to chime in for purposes of adding, subtracting, or correcting.
Hi, everyone. Can you hear me? Okay.
Yes.
I'm really sorry I couldn't be there. I had COVID last month, and it just knocked me out for a while, and I got nothing done, and I still am awake for about 4 hours a day. I educated Fred about analogy pretty much over the years, the empirical side anyway. And there's just two things I want to add. One is that as a cognitive psychologist, it's absolutely clear to me that almost everything we think about, do, think, reason, remember, all of our cognitive interpretations of things depends on two things. One is what really is out in the real world, and I'm sorry if I'm offending any philosophers by saying that there really is stuff out in the real world. And the other thing is what's in our heads. And somewhere between those two things is how we interpret the real world. And that's kind of what Fred was saying. We have education experiences and we have the real world. But one thing that more and more we're finding is that also desires and wants matter to that. Sometimes you see what you want to see. You interpret things the way you interpret them. If I was there, I'd have some slides with the number 13 and the letter B, and if you ask some people, who want to see a B, they'll see a B, and if you ask some people who want to see a 13, they'll see a 13. So although I'm a big fan, and we've written about this, about the knowledge experience and all that other stuff, somewhere in there may be desires, what you want to see. If you go in looking for differences, then you'll see differences. If you go in looking for similarities, you'll see similarities in the typical way that you might argue in appellate argument on the same cases. One side says, oh, it's really, really similar, and the other side says it's really different. And then the other thing I want to stress is the notion of superficial resemblance versus structural resemblance. I don't think we said enough about structure. So although, Fred, I hadn't read the whole paper until last night, actually. I love the mustache example. But when we think about A is like B, usually we're thinking about it in terms of similarity in a simile kind of way, right? This mustache is like that mustache. But in order to think about analogy, it's A is to B like C is to D. So there has to be more, there have to be parts, there have to be relations. How is A like B going to be like C is like D? And if you saw, I think it's one of the first references in the paper. I once wrote a paper with my advisor called "If Saddam is Hitler, Who is George Bush?" And you can't really say those two guys are too much alike, except being guys and alive in the 20th century. But what you do is you instantiate a whole bunch of things that he did, and it's not just he's a bad guy. Things, invasion, what he did to the people, what he did to the Kuwaitis, all that other kind of stuff, and that he wants to conquer the world, and that's how Saddam is like Hitler. And then you extend and you say, okay, well, we have then George Bush. What role did he play in this whole big structure? Who was he like in the past? And I don't want to lose that it's really A is to B as C is to D. And we need more parts than just like, they have similar mustaches, they're green, kind of embarrassed that Thomas wrote about the green example. But green is one of those superficial characteristics, and you really need to know structure. Oh, and also the last thing. I think law is really about the relations, and it's not about superficial similarities. And I've been wanting to write a paper called something like, the Analogical Constitution or something like that, or Law is Relations, different one, where usually we don't really care about characteristics like whether somebody has a mustache, or usually we don't care about things like whether somebody's older or younger than 18. But sometimes we do, but we usually don't care about whether people are 35 or 70, and usually we don't care about most of the characteristics that people have, and they only come up when it's in relation to some other kind of thing. Okay, I'll shut up now.
Okay, there are other people who have to speak, so we will stop.
Thank you, Professor Spellman and Professor Schauer. Thank you very much. We'll turn it over to Professor Parker.
Thank you. Is it okay if I sit here, or do you want me to? Is that okay? Oh, that's fine. That's fine. So I want to thank Darryl Miller in particular for the invitation to come here, and also the students for doing such a great job. And I will add that I really am an interloper in this space, right? I hadn't really sort of focused on much of this stuff before I started working a little bit on this paper. What I want to do today is just briefly talk about the differences, at least as I see them, between how professional historians think about historical time and this notion of history as analogy, and then I'll say a little bit more about how I situate the Brune opinions. So modern professional history is heavily committed to the idea of temporal difference over time, right? So for historians, time is both a marker of and an engine of difference, right? Something in 1800 is necessarily going to be seen as something different from something in 1900 because they're different chronological moments. And even as the passage of time from 1800 to 1900 is going to be understood to produce difference, right? So given this commitment to temporal difference, which the philosopher of history Reinhard Koselleck sees as a kind of very modern post-French Revolution kind of idea, right? Professional historians are undoubtedly going to find somewhat alienating the practice of history as analogy, where analogs from different time periods are sort of lined up on the basis of this or that criterion to lend support to or to withdraw it from current regulations, right? So history as analogy is a way of stringing together analogies is going to be strange to professional historians for yet another reason. Insofar as professional history establishes temporal frameworks in which terms of which objects are understood, history is actually infinitely accommodating. Right? Nothing is ever cast out of it. So for example, if we take, Jacksonian America or Ancien Régime France or what have you as a frame, professional historians are not going to eject anything from it, right? Everything that occurs in the United States between 1820 and in the 1820s and 1830s is going to be seen as part of Jacksonian America, right? So it's not that professional historians will not hesitate to characterize something as mainstream or something as out of step, but the idea of locating something anomalous within a time frame, in fact, is more likely to compel them to think of the frame itself differently or the context itself differently, right? So Jacksonian America, as a result, can become infinitely more complex if you throw in more and more things that look different from what we think the mainstream is. And complexity in historical knowledge, modern historical knowledge, I would argue, is a historian's way and also an aesthetic for acknowledging and recognizing the difficulty of getting at truth in the first place. Everything is potentially true because nothing is really not true, right, in this sense. And for this reason, professional historians do not excise outliers, right? That would make no sense to most professional historians, but that is actually central to the way Brune works, right? And to be sure, professional historians have disciplinary rules of evidence, norms of contextualization, styles of argumentation, but the adjective administrable would actually not be seen by professional historians as something applicable to the discipline, right? Having said all that, let me switch gears so you can see a little bit the difference between what professional historians do, how they think about time, and the way Brune does. Having said that, let me switch gears to say that there's, and I try to start out the paper saying this, that there's a long tradition of professional historians criticizing lawyer uses of history, and it goes back, certainly to the beginnings of the post-World War II period, and no doubt earlier. And I actually, in the paper, but also in my work, my first book was actually about the relationship between the common law and history, eschew that way of thinking about law. I mean, I'm more interested actually in how lawyerly notions and uses of time and temporality can serve to sort of impel professional historians to reflect upon their own modes of thinking, right? Sort of what is it about lawyers' approaches to thinking about time that historians can use to think about their own temporal strategies. And having said that, I try in the paper to sort of think a little bit with the Brune history as analogy sort of approach, and to see what it can get professional historians, what it can do for professional historians in the way they think about what they do. So I will also add that when I was asked to come to this symposium, I was in the process of finishing a book that's actually going to come out this month on a sort of development both in not both, in American law, but also in American political science and in American economics between sort of the 1870 to 1970 period, which looks at transformation where you see thinkers moving away from what I call sort of truths to methods, right? There's a kind of shift which you can document in all these disciplines, but you can also do it in other disciplines that I didn't talk about. There's a book right now on the history of mathematical thought where you can see something very similar going on. And so what I trace, and a little bit in the introduction of the paper, is look at means-ends tests, right, as a sort of outgrowth or a development of this larger development in legal thought. And then try to think about originalism also in relationship to this larger shift in legal thought, right? And one of the things that I thought was really interesting when I was reading the Brune opinions for the first time was, and this book comes as no surprise to anyone, is how Breyer's opinion really harkens back for me to this older process tradition, right? Which really looks like, not dissimilar in some respects from what someone like Felix Frankfurter might have said. Right? There's a kind of sense in which the deferential position that Breyer takes relative to democratic decision-making is part of this older tradition. And I wanted to suggest that, in fact, constitutional originalism, there are many things to be said about constitutional originalism and the sorts of claims it makes for itself, but it is also, it also takes seriously a certain kind of deference, right? And the ability to actually locate meaning in decisions in the past is as much a part of, as related to a suspicion of judge-made lawyerly knowledge as means-ends tests. And you see a kind of, in the Thomas opinion, in fact, there's an explicit weighing of means-ends, interest-balancing type stuff, from earlier decades with what he calls constitutional originalism, right? And so both, I argue, are tools, right, and are quite self-consciously tools, right, which is a very different way of thinking about history from an earlier period, for instance. And what I do in the paper is try to think about, well, if both are tools, if means-ends tests are tools and history is a tool, right, history as analogy is a tool, how do we compare them? And the opinion, at least the way I see it is, of course, as you know if you read the paper, is that the Thomas opinion really is an example of a kind of tool gone rogue, right? A tool that's sort of taken over. And I think it's sort of, anyway, so that's my critique of the opinion. But I also do want to use the approach as a sort of useful way of thinking for historians about the development of their own contextualizing practices. So I know we have another paper, we want to have time for discussion, so I'll just end there.
Thank you very much. I want to join my fellow panelists in thanking the organizers for the invitation today, especially to the students for all of your hard work in ensuring that whatever we produce is going to look much better than the way you received it when you got it. I want to also begin with my kind of obligatory disclaimer that, like others, I came to this project not as a firearms person, although given Professor Bloker's introduction, I guess I am a firearms person now, so this is my confirmation. And I know I would have worn a better suit. But the perspective I come to this from is not so much an expert in Second Amendment or firearm law, but rather as someone who has thought at least a little bit about the role of interpretation and originalist interpretation particularly within a judicial hierarchy. How should we operationalize some of these issues if we're going to give this kind of significance to history? How does that work in the actual structure? And I should also disclaim I'm not an expert in cognitive science or psychology or a professional historian. I'm just a simple country lawyer, and that's the perspective I'm trying to approach all of these questions from. So I'm very much focused on how is this going to work in the real world. And I think what is distinctive about both Bruin and some of the other courts' recent decisions is that they are making history and propositions about historical fact much more relevant than they have been to recent periods. So I want to just plan my sort of remarks. I'm going to say a little bit why I think what the court's doing now is new and distinctive from the way history's been used in the past. Say a little tiny bit about what Bruin said. I'm going to assume some familiarity in this audience I wouldn't otherwise do. Talk a little bit about some of the problems lower courts have confronted. And then talk about some of the challenges I see from the Bruin Court's guidance, some unanswered questions that are going to render this more complicated in practice, right? So first question is, what is so new about looking to history, right? Don't we do that all the time? Well, of course, history is a major part of constitutional law, but as I argue in the paper, I think there is a distinction between the way history has traditionally been used and the way Bruin and similar cases are suggesting it should now be used. Mostly when courts have looked at history and constitutional cases in the past, they've looked at it as a guide to interpretation, right? The meaning of actual words, what is the legal rule that emerges from this piece of constitutional text, right? And that is fairly comfortably classified in our legal tradition as a pure question of law, right? It is something that is outside our ordinary structures of proof, right? It's a question for the courts, not for the jury, not bound and guided by defined evidence rules, etc., right? So as long as we're confining history to that project, I think we have a pretty accepted framework of how this works, and it also facilitates this division of responsibility between the Supreme Court as the ultimate expositor of law and lower courts, which tend to focus more, comparatively more research on more fact-bound questions, the particulars of who, what, when, and why of a particular case. Now, Bruin I'd see as a little bit different, because now the court is increasingly using history as a guide not only to interpretation, but to application, how the rules should work in the real world. The critical move made by the Bruin Court is to displace the tiered scrutiny framework that has kind of predominated many areas of constitutional law during the latter half of the 20th century with this new focus on history and tradition, which is going to make very significant what those historical facts actually are, right? What was the content of 18th and 19th century law? What were the purposes behind those laws? What effects did they have on the real world? How common were the weapons that were affected or targeted by these restrictions? All of these questions need to be answered by the courts going forward, and Bruin provides comparatively little guidance about how lower courts are going to confront this issue. The most specific instructions it gives are largely in response to Justice Breyer's dissent, where Justice Breyer raised a lot of pragmatic concerns about how this structure is going to work in the lower courts. And the Bruin majority's answer is essentially that, well, courts have well-developed principles of evidence and default rules for dealing with uncertainty. Therefore, the lower courts are entitled to rely on party presentation to resolve these questions, right? Just consider the evidence presented by the parties. Burden is mostly going to be on the government. If the government can't display the relevant history and tradition, government loses, right? Just that'll resolve most of this uncertainty. At least that's the prediction that the Bruin Court is working from. Now, I don't find this an entirely satisfactory answer for all of the problems the courts are going to confront, because I think there are some limitations for party presentation with regard to particular kind of factual inquiries that I see as present in the historical fact inquiry. Now, of course, lawyers and courts often have to deal with subjects they're not experts in, right? We consult economists in antitrust and securities cases. We consult chemists and scientists in toxic tort cases. But when the legal system incorporates that kind of knowledge, in most cases, it's doing so on questions of what are sometimes called pure adjudicatory fact, right? The who, what, and when of a particular litigation, right? Did this particular plaintiff's chemicals cause injury to these particular plaintiffs, right? Is this particular company's market structure such that they have dominance over the market, and was the course of conduct they can pursue anti-competitive, right? Now we're very comfortable dealing with those kinds of facts. Even historical facts can come in that way, right? If we have a question of ownership of a very old chain of title, right, we may consult a historian to find out the relevant events. But I think the questions that the Bruin Court asks us to answer are a little different. I think they're not the kind of questions we want repeatedly asked and answered in this case-specific process. They're questions about general facts in the world. General facts that ideally should be true of every case to which they should apply. They are facts of the type that are sometimes referred to as so-called legislative facts. I have some problems with that terminology, just kind of suggesting a particular role for the court. I prefer non-adjudicative facts. I'm going to try to make that happen a little bit in this essay, but we'll see how that goes. So these kinds of non-adjudicative facts, I think, are problematic to deal with on a case-by-case basis because it's going to lead to huge duplication of effort, inconsistent treatment of litigants, including potentially in the Bruin context, criminal defendants, going to lead to uncertainty, unpredictability about how the rules are going to apply in the real world, which is going to affect both potential owners of firearms, those who want to seek firearm ownership, as well as governments responsible for enforcing these laws. And I don't think we have a really good, well-developed set of ideas throughout the legal system for dealing with these kinds of non-adjudicative facts, right? These are relevant to the tiered scrutiny framework as well. And we've kind of tried to get by in a much more haphazard way in dealing with those kinds of facts. Appellate courts often think they are not bound by lower court determinations with regard to these kinds of non-adjudicative facts in the same way they are with case-specific facts. They consider other evidence, such as amicus briefs, and their own independent research, sometimes just their common sense intuitions. And if you look at the Bruin majority, after they get done telling the lower courts they can rely on party presentation, that's exactly what Justice Thomas does in reviewing the relevant history, and the outcome of his pronouncement seems to be a precedential ruling, not just that this particular government defendant failed to meet his burden of proof, but that no such law shall be permissible going forward. So I think this is a challenge that lower courts are going to have to confront working with the historical fact inquiry that Bruin suggests. It's a the problem that confronts all non-adjudicative or legislative fact-finding. But now we're putting it in a different framework, one that lower courts are a little less familiar with dealing with. They've kind of worked out some systems for dealing with legislative facts in the tiered scrutiny framework. Now we have to translate some of those ideas into this much different posture of historical fact-finding. And to the extent I have guidance, and I don't want to tell an overly optimistic story about the legal system's ability to handle these processes or the challenges that are being presented, but I do think there might be some reason to hope that the legal system can work this out over time. But in order to do that, I would think we would kind of want to take a tentative step in the early stages at least, not be too quick to set precedential rules regarding these questions of contested history. Experiment in the lower courts, particularly advise more minimalist type of decisions that don't decide too much too quickly, that leave room for things to play out in the lower courts. Such an iterative process over time might reveal new historical facts, or at least give us more confidence that the historical facts we have found are most of what's out there, such that they can ripen into some precedential rules that will guide and constrain decision-making going forward. What I'm concerned about is deciding too much too quickly, locking in precedential rules that might reflect an incorrect view of history, and that might therefore be harder to displace at some later point when we discover that our history might not be as convincing as we once thought it was. All right, so thank you all. Look forward to questions.
Thank you to all of our speakers. What we'll do is I will just raise a question or two, and among the panelists, if you have comments on each other's presentations, those will be welcome, and then we'll open the floor to questions. I guess my comment is along the lines of this whole the connection between the three papers, for me, reflects that the problem that Bruin presents is one that is the problem of the legal system. How do we assign to judges who are generalists in the federal system, wearing a black robe, trying to be external to themselves, recognizing that people have individual experiences, knowledge, expertise, and tastes. We expect judges to lay that aside as best they can, self-consciously to lay that aside as best they can, engage in traditional legal reasoning, which as first-year students learn is how to decide when one situation is relevantly similar to and relevantly different from another. We have a set of constitutional doctrines across a great number of doctrinal areas that have developed over time in a system of precedent in a path-dependent way that has led to, in equal protection law, tiers of scrutiny, First Amendment law, similar tiers of scrutiny, some put somewhat differently. And the Second Amendment in the issue in the Bruin case presents a bit of a perfect storm because there isn't stare decisis at work. And then you add into that the fact that we have now a majority of justices committed to an interpretive methodology connected to the original public meaning of the document. You have to figure out how you're going to resolve these cases. And in the absence of plugging in what were tools used doctrinally to try to give effect to other parts of the Constitution, well, if precedent doesn't require that, what in substance are we really after? Did the people of the United States, through their Constitution, impose a limit on lawmaking of the sort that it stops them from, in this instance, regulating stopping public carry? And so I guess my comment is, isn't this just like everything else, but without precedent?
To some extent, yes. I'll stay here for now. I think that's certainly part of the problem. I think, but the lack of precedent matters, right? We have precedent for reasons. Precedent makes things easier. It makes it more cost-effective to resolve these things, right? We don't have to relitigate everything each time it comes up. So anytime you another way of recharacterizing the question or further gloss on the question might be: is this just the kind of disruption that's going to change any major change in constitutional jurisprudence, right? Some of these questions had to be worked out in the aftermath of 1937 as well, right? Some of these questions had to be worked out in the civil rights revolution of the 1950s and 1960s. So one question is whether this is materially different. Is there something that is more challenging about the reliance on history than some of the other questions that courts had to confront in the earlier periods? I think it's a good question. I think we'd have to think more deeply about that. I do think it takes some options off the table that were available to decision makers. For example, in 1937, the fallback was deference, right? If we're uncertain, we just defer to the legislative bodies or other politically accountable mechanisms, and that kind of be our kind of all-purpose rule. I'm not sure we have that clear guidance yet developed in the context of the transformations that are happening now.
Let me just add a footnote to the without precedent part. There's a series of interesting articles by Allie Larson from William and Mary, in which she explicitly takes on this question, that is, can factual determinations by appellate courts be used, or should they be used, as precedent for further factual determinations as opposed to legal determinations? Her answer is complex, but worth reading on this question. I also might want to mention that our two bête noirs, pardon the pronunciation, in this paper surface in this area as well. That is, Justice Breyer and Judge Posner are pretty much the leading figures in casting aside the normal constraints on appellate judges and going off to do their own factual research, apart from what one might find in the arguments, apart from what one might find in the briefs, apart from what one might find in the record. For Justice Breyer, probably the extreme comes in his lengthy dissenting opinion in Parents Involved for the Seattle schools, in which he thinks it both useful and appropriate to task his law clerks with extensive factual research about one of the parties in the case before the Supreme Court. And Judge Posner, who doesn't lack for modesty or immodesty on this subject, has been fond of saying that he wishes the lawyers in the cases before him did a better job, and because they don't, he has to go off and do his own research, which sometimes involves an even more novel use of law clerks, using them as experimental subjects. He does amateur psychological research in which he has the clerks do stuff. And he interprets what they are doing as good empirical evidence for how people behave. That assumes that law clerks are representative, and it assumes that Judge Posner is a good interpreter of that, but he was out there when he was active, out there on the cutting edge of saying, it is my job as an appellate judge to do whatever factual research I find necessary.
That arouses in me a comment. I think it is striking the sometimes similar behavior of Justice Breyer and Judge Posner, but I have to say, in my own gut, my reaction to the two is quite different, because I understand Justice Breyer's methodology to be one of self-consciously pragmatics. I want to connect the legal conclusions to the real world in a way that is actually sensible. Judge Posner, by the end of his career, was self-consciously not doing law. He says it, right? He says, I pick the result I think is best for reasons external to the law, and I engage in false legal reasoning to get there. I mean, he's explicit about that. And I don't think Justice Breyer thought of what he was doing that way, and I don't think that, unless he was engaged in false consciousness, he was fooling himself. And so do you think that there is a difference, that difference is real, and do you think that that difference matters in terms of the quality, legitimacy, acceptability, et cetera, of the judge's behavior?
So I think that the distinction is real. And if this were a jurisprudence conference, I would suggest in more detail that the difference between them is really a difference about the definition of law. On the surface, Judge Posner may say, I'm going beyond the law, but what he's really doing is offering a capacious understanding of what law is. Justice Breyer may have in his mind a somewhat narrower definition of law in mind. And the question therefore is, what is law, or the questions, what is law and what is the relationship between law and what appellate judges do? I think in some sense the difference between the two boils down to what they think law is. But this is not the occasion for that.
Well, forgive me, it's evident that I too am not a gun guy. And it's not often that you get a chance to ask Fred Schauer direct questions about judging law, so I took that opportunity. So with that, we'll open the floor to any questions or comments from the audience.
Thank you so much for this fantastic panel. I'm wondering, and I apologize, I have not read all of your papers. So with that in mind, please take this question for what it is. I'm wondering, Bruin at times seems to suggest that an analogy, singular, is enough to uphold modern regulations, but an application seems to suggest that there needs to be some kind of critical mass, either in coverage of population or a number of laws. I'm wondering if in your papers you've thought about how these suggestions for better analogy or slowing down the courts and making these broad pronouncements addresses the need to find this national historical tradition. And what that exactly means is there's some principled way for historians to identify a tradition for application in particular cases.
There isn't. Right? I would not say that there is. And in fact, one of the things that strikes me about the Bruin opinion is precisely or the majority opinions is precisely its lack of principle on those issues, right? So sometimes you're told 3 analogies are not enough. 2 analogies do not constitute a tradition. Because they're only in the 17th century, right? It's some of the stuff that I tried to point out in the paper, which I think others have done too. I mean, there are other papers out there that criticize Bruin on very similar grounds. But no, I would, it's not, let me put it differently, right? And I actually don't have a problem necessarily with the sort of lawyerly use of history as analogy. I just don't think that it's a particularly good exemplar of that approach. This opinion is not a good exemplar of that approach. So, lawyers should do what they want with history, and historians should do what they want. And one of the things that I've been very insistent on is nobody owns history. Certainly professional historians don't, right? Everybody has access to the past. Everyone can create the narrative they want about it. I just don't think that Bruin does it. To the question of whether there is something called a national tradition, right? History is a big field too. My sense is this is not a question that would be interesting to most of the professional historians I talk to, certainly.
So this is I think this is a follow-on to the question. It's really about, and it's also directed to as a historian, which is, when I talk to other historians about this, coming from the law side, the answer I get is often like that, which is there's a bunch of historical realities that happen, and there's a narrative that's put together. It's always contextualized, it's always in flux, it's always another country, and then there's the thing that like what Will and Steve have said, which is the lawyers come in and try to use that data to figure out what part of this is the law. And I think you seem to land and say, well, that's okay. But then my question is, what exactly is the enterprise about originalism doing? Because as I always understood originalism, it is, even original law originalism, is taking a set of empirical realities that is being produced off stage by people like historians, and then using that as a way of trying to ground decisions that aren't just baked into whatever the ideology of a particular judge is. So if the lawyers are trained, the historians are essentially saying, there is no there there, do what you will, then does that undermine the originalist project as a whole because they're resting on a false premise, or am I misunderstanding the nature of the contestability of history and what historians understand historical reality to be?
I mean, it's a really complicated question. I think part of the reason, I think that something that I would call modernist knowledge is always sort of working towards some mirage out there, right? And in the originalist idea, it might be history, like the security that history gives you. I don't think historians would think that. But that doesn't actually, it doesn't strike me as a problem for originalism. I think, you know, originalism should do what it does. And I think one of the things that I tried to do, at least self-consciously in my paper, is not approach this as a historian might, right? At least not reading the Brune opinions as a historian might, for very good reasons. I know nothing about the history of gun regulation. Like, that's not my thing. But I think it's on its face. I think it seems kind of not very convincing. And my sense is, I could be totally wrong, right? You could poll a lot of legal thinkers and ask them whether they're convinced by the narrative you get in the Brune opinion, and I would guess that a lot of people would also say we're not so convinced, right? I mean, one of the things that I liked about Breyer, notwithstanding the criticisms that we've heard about Breyer and Breyer's approach, in this, one of the things that I like about his dissent is that he keeps the uncertainty of the historical record sort of front and center, right? So he doesn't simply say, he does say at one point, yes, there is a national tradition of regulation, but he also says, but if you don't agree with me, at least we can agree that it's deeply uncertain. And if it's deeply uncertain, there isn't the ground, right, that you want. Therefore, what do we do? Right? That's kind of how I read him. And I think that actually seems convincing to me, but.
I guess this is a question about relevant similarity in history, but so I take the point that, you know, the history alone, these analogies alone is not enough to resolve these cases. You need more kinds of principles. And I guess my question is, Brune tries to supply some of that, and so the question is what Brune tries to supply not enough, and if so, what do we need? So right after the famous analogies paragraph where they quote Fred and Bobby, the court says, you know, we need principles of relevant similarity. Here are two. How did the past gun regulations burden the right to keep and bear arms? You know, was it a complete ban? Was it a sort of need for a license? Was it something else? And why? What was the purpose of what was it trying to accomplish? And look for those two principles. And they say we might need more. So I guess the question is, are those two enough to kind of make this work? To ask, you know, how did we regulate this in the past and why? And if those are not enough, what more, and you imagine the court coming along to supply additional principles, what more would it need to say?
I guess, a lot is built into what you say is make this work. In her part of our presentation, Bobby made reference to what psychologists refer to as motivated reasoning, that in observing the factual world, what you want the factual world to be plays some role. But some is not everything. And I think part of the task here is to figure out what are the constraints. In some circles, saying objective reality is fighting words in First Amendment terminology, but not in the circles in which I travel. There are objective realities out there, and it may be that how people interpret the objective reality at the edges is significantly a function of what they want to happen. But that's not the same as saying there's no there there. It's not the same as saying it's all empty. So at least I think motivated reasoning plays a big role in all of this, but maybe motivated reasoning constrained by plausible interpretations of the actual facts.
I hate to say that Fred's actually right about something. Yeah, he's right about that. The concept of motivated reasoning is taken now. People think it only means you want to get the answer that you want to get. But the original research shows that we're motivated by several things in our reasoning, and one of them is to not look like a fool, and another one is to be right. So it's great if our answer is the right one, but we're not just going to come up with crap to say and have, because we want other people's respect and we want to be right. So that's an important part of this. And I want to, if I can, just go back a little bit in the conversation to whether one analogy is enough. And analogies, they're sort of like categories. That is, if you look at two and you say, oh, they're very, it's like cases in a lot of ways. You look at two, you say, oh, these have similar structures, but no one thing is identical to everything else except for itself. And so you create a group of analogies that have some similarities and some differences. And so I wouldn't say you'd want to always go just from one to another, especially if they don't have a whole lot of characteristics, unless they're very, very simple, like some visual analogies.
So I just want to say in response to the question, the why part, the second part was actually, when I read the opinion, was actually kind of deeply ambiguous to me, right? I thought, what is the why? Because at a later point in the opinion, the motivation behind a regulation actually matters, right? So the way he talks about the Tudor regulation of arms, right? It's about allowing crossbows or whatever to flourish and not, and so that's not good enough as an analogy either. So I think, but for me, the worrying thing is not the questions, it's actually seeing the uses of the evidence and the constant shifting of goalposts in the opinion. So it's, if, the questions can actually be worked out, I think, with much more integrity, with respecting the evidence than is actually the case in Justice Thomas's opinion. At least that's the way I read it.
So I read it, I think, what struck me when I read the Bruin opinion is sort of how much permission it gives within the framework. It sets guidelines, but in many ways they're very loose. They say this is relevant or this is less relevant, and not say, it doesn't say you need at least 3 historical examples to set the precedent, right? It doesn't make clear that one might not be enough, right? It just leaves a lot of things unsettled, which is frustrating, I know, but for some of the same reasons I kind of am skeptical of overly broad historical propositions, might be a good thing for this early in the process, that we have a lot of questions unanswered. We're answering some questions in the context of this particular case, kind of providing an illustrative example of how we're going to apply these rules, but has not, at least as I read it, I don't think it's quite as categorical as some of the lower courts have understood it or characterized it on some of these issues.
Mr. Brain?
I have a question about whether analogies are the kind of thing we get better at. Are judges better at analogical reasoning now than 150 years ago? Should we expect to be better at it 150 years from now than now? So if you'll pardon an analogy, is it like physical sciences or more like art?
Maybe we should defer to the analogy expert.
It's not clear that people get better at analogies as analogies, except after their kids aren't that great at it. We get better at more complex ones. But the improvement is really in our knowledge and our knowledge of what's out there, how things are related, all that kind of thing. So I wouldn't say it's the abstract version of analogy that we're getting better at. It's the particular version of analogy. Lawyers, I think, 2 things. First of all, we're much better at legal analogies than regular people because, we know all the stuff and the relations and the stuff that matter. And the second thing is we're more likely to use analogy because we use it so often that it's a normal way of reasoning, where for lots of other people it's not, in their first line of attack, I hate to.
So, your question might also go to, we could broaden it. Do people get better at legal reasoning, whatever legal reasoning is? Is it reasoning with rules? Is it reasoning with analogies? Is there actually is there improvement in all of this? A lot of us, including you, make our living on the assumption that this can be taught and that people can get better at it. Whether that's actually true, I'll leave for another conference.
But I just want to add that in the Thomas opinion, he says the question of whether you can get better at it is elided because he says this is what we're good at anyway, right? Like, this is everyday stuff for lawyers. So the question of, right?
Yeah. Yeah, he uses the word commonplace.
It's commonplace. It's something that's already there. It's a skill we already have.
I think it's very plausible to me that an individual person gets better at constructing analogies within a particular field as they do it more often, right? So think my experience grading exams, right? A lot of it is comparing one to another, right, and assessing them, right? I'm a lot more confident doing that now, earned or unearned, than I was when I started the process, right? You know, people study for the LSAT, they get better at the logic games and the analogies, right? Now I think the challenge for analogizing that to a system-wide improvement, I think it's going to be more challenging because I'm less convinced that story holds, and within the legal sphere, the analogies we're drawing change constantly, right? The reason we're drawing analogies, our principles of similarity and difference, change with the underlying legal rules. So an 18th century lawyer would be much better at the analogical reasoning called for by 18th century law than would a 21st century lawyer, which is part of the challenge that Bruin puts upon us, right? Because now I have to go back and try to think like the 18th century lawyer. But maybe if we're doing that more often, maybe we will get better at it, or maybe particular practitioners will get better at it once they get more familiar.
This is a question for Professor Spellman and Professor Schauer. Do you think that your correction of the record about how analogical reasoning works should make us think better or worse of Bruin? So one of the most common critiques is that the traditionalist analogical criteria it gives are totally manipulable, and this is such a politicized area that judges are just going to run wild with what they want. And half of your paper seems to be saying, actually that's not how it works, it's a lot more constrained, just as a matter of empirical psychology than that. And you do say, well, there's another problem that we do face, which is analogical reasoning often happens in a superficial level. You know, does the gun look right or not? But that sounds like the kind of thing that it's much easier to correct by just looking more deeply at the relevant information. So is it a note of optimism?
So one of the things that I have learned from my co-author is it's almost always the right question to ask, compared to what? And I think it's easy to criticize the Bruin opinion for, let us say, its excess optimism about the possibility of constraints and the degree of constraints. But if we ask the compared to what question, it would be interesting, and I think I can imagine constructing an experiment to do this. It would be interesting to see whether the not as constraining as Justice Thomas thinks it is methods in Bruin actually would produce a narrower range of outcomes than, let us say, hypothetically, living constitution approaches to firearms control, or Posnerian unconstrained pragmatics approach to firearms control. So although we maybe are not fans of this opinion or this approach, and neither of us would consider ourselves as originalists, the question of whether originalism in some form, including this one, is more constraining than other methods is different from the question, is originalism in some form a good idea for reasons of political and constitutional theory? And I'm inclined, speaking just for myself, to think that it may be a bit more constraining than other methods, but that leaves open the question of whether on other dimensions, on dimensions other than the degree of constraint, it might still fall short.
Well, we are out of time. Thank you so much to our panelists for a very interesting discussion.